Everyone, and thank you for joining us this morning for what I consider to be a very exciting seminar discussing the recent judgment. And we are very honored to have Advocate Raja Badlander with us this morning. It is an honor to be able to discuss it with you and to have your expertise on this matter. I hope you don't mind if I call you Nasreen this morning. That's not too familiar.
No, please do.
Perfect. What I'd like to do is just provide some background, because I assume, as many questions, if not more, than some of our attendees after this judgment. I think we've been watching the media or keeping an eye out for this matter. We've been following it all along. It's an incredibly exciting matter to have been involved in, I'm sure. But let me perhaps just take stock of where we're at. And then I'm going to hand over to you, Nasreen, to just give us a bit more insight. And then we'll see if any of our attendees have any interesting questions for us. So, to take stock, the Basic Conditions of Employment Act historically provided for 4 months maternity leave. That was amended, and in that case, this is 2 years ago, if your partner, and in referring to partner during this webinar, I think let's assume that's an all-encompassing term for whoever is the supporting partner in whatever relationship you may be in. Your partner would have had family responsibility leave. We were very excited about the amendments in January 2020, changing that to 10 days. So now whoever had the primary responsibility for the baby would have the support of his or her partner at home for an additional 10 days. And then the Van Wyks came along, and my understanding of their personal circumstances are that Miss Van Wyk owns 2 businesses and her husband is employed as well. And it was their election that it would have been for their family arrangement more suitable for him to take care of take the primary responsibility of nurturing the baby. And on that basis, they challenged the provisions which existed at that time. And at that time, the provisions were 10 weeks for adopting and surrogacy arrangements, 4 months for a mother who births the baby, and then there's 10 days for the supporting partner. So that's where we're at. If I can hand over to you to tell me in crux what the challenge was and what the argument was in bringing this matter to court.
Yes, thanks, Anli, and hello to everyone that's attending this morning. So essentially, I represented the Van Wyks. They very in their personal experience decided that actually the way the law functioned was out of kilter with the way in which they wanted to run their family. So as you said, Mrs. Van Wyk ran 2 businesses, and Mr. Van Wyk was also employed. They're both highly skilled individuals and highly educated individuals, but they were in the position that if Mrs. Van Wyk took maternity leave, there was no one to run her businesses. They're 2 small businesses. Annie, I'm just going to pause. I think there are lots of people that say they can't hear, but there are equally people that can hear. So perhaps just leave and rejoin. Okay, so Mrs. Van Wyk could not take maternity leave effectively, or could not take more maternity leave than a very minimum number of weeks. Otherwise, her business would have suffered. Mr. Van Wyk decided, well, he would stay home and he would be the primary caregiver. So he went to his employer and indicated that he wanted to take 4 months parental leave. And the employer naturally said, our policies don't provide for that. And our policies were largely in line with the Basic Conditions of Employment Act. And so you can have 10 days. But obviously that wouldn't have worked for them. They then decided to approach a court because when they took some advice, they realized that the statute was unconstitutional. And their sense was that it discriminated between men and women in terms of who could stay home and be the primary caregiver. And that is the point at which I got involved. What happened for Mr. Van Wyk was that he effectively had to take unpaid leave. Most of it was unpaid in order to stay home with his child. So that's sort of the background to the case. And once it got going, the Centre for the Commission for Gender Equality joined as an applicant. Sonke Gender Justice was the third applicant. And then various amici joined. I think there were 6 of them, and in the end, 5 of them participated in the proceedings and made representations.
What I understand to be the outcome of this judgment, and then we'll go into a bit more detail, is that now the provision would be, and let's just pause what it means immediately, but the provision would be 4 months for a family. I think that's the easiest way to explain it, per parental family or parental setup. So that would be for you as mother, father, or regardless of what your family relationship may be, to decide who takes what and who gets to stay at home. Is that accurate?
Yeah, and I think the sort of almost last penultimate paragraph of the judgment summarizes the position, which is Judge Sutherland says, all parents of whatever stripe enjoy 4 consecutive months parental leave collectively. In other words, each pair of parents of a qualifying child shall share the 4 months leave as they elect. So the idea is that you as a family must decide how you want to regulate your affairs. You've got to decide how you deal with parenting and child care responsibilities. But there was some debate in the court. Some of the applicants wanted the relief that was granted to be that both parents could get 4 months consecutively at the same time. We were of the view that really what you wanted to be able to do was to allow a family to choose who was going to be the primary caregiver, and for that person to get 4 months. In the final analysis, Judge Sutherland has gone further than our proposition and has allowed parents to actually even share the 4-month period between them. But there is as I read the judgment, there's a maximum of 4 months. It's not that you can each take 4 months consecutively and ultimately get, for example, 8 months. That's not the effect of the judgment.
So what's the impact of this judgment at this point? So what is the status for employers currently?
Well, the way it works is this. The High Court has now declared the statute unconstitutional and has suggested an interim reading in before the statute is amended. But our law requires that where you set aside, where you find a statute unconstitutional, it must be referred to the Constitutional Court for confirmation of that order of invalidity. So the next step is that you have to now move on to a confirmation proceeding in the Constitutional Court. So we're in the process now of preparing that application. The minister will be entitled to answer, and the other parties will answer, and then the Constitutional Court will set that down for hearing. In that process of hearing the confirmation of this judgment, the Constitutional Court effectively rehears the matter, because we will re-argue the matter before the Constitutional Court. They'll be entitled to test any propositions with us. They'll be entitled to test the relief granted by Judge Sutherland, and ultimately to decide whether to confirm the High Court order or decline to confirm it and find that the statute actually was constitutional. And the Constitutional Court, importantly, can also amend the interim relief, so that the Constitutional Court could find that the statute is unconstitutional and suspend that finding of invalidity for a period of time to allow the legislature to come up with an amendment to the legislation that meets the problems that the courts have identified. And the Constitutional Court could also say, while the Parliament is doing that, here's an interim reading in. Here's an interim state of affairs that will apply. And the Constitutional Court can even go further by saying if Parliament doesn't, within the period, it doesn't change the legislation within the period provided by the Constitutional Court, that their interim reading in becomes final. So there are various things that can still happen. The important takeaway from this is that the High Court judgment doesn't change anything right now. So the important thing here is for employers that it does not mean that men can come to court, come to your employer tomorrow and say, I want 4 months leave, and if it's contrary to your policy, that you are required to do it because of this judgment. Employers are, of course, allowed to amend their policy at any point if they see the writing on the wall and they decide that they want to progressively work towards this, then they're welcome to do so. But the Act, as it stood before the judgment, currently still stands.
Yeah, and I think that's very important because the questions that we've been receiving most is what now and when do we have certainty? So that the timing aspect, I'm not sure if you're able to say what that may be, whether you'll be in court next year or the year thereafter, but I'm assuming it's not imminent. We're very unlikely to get an outcome this year, just to relay everyone's concerns.
Yeah, I think, it's a little bit hard to predict, but I can give you a sort of general sense looking at what the court has been doing. As I say, our confirmation application will now go in before the end of the year, but the court has already started setting down matters for next year. So I would anticipate that the Constitutional Court is likely to only hear this probably in the third term of next year. And then, of course, we wait for a judgment. So I don't think there's any imminent change, but I do think that this is an indication of where things are going. That my sense is that that our constitutional challenge was strong, and that at an absolute minimum, the differentiation between men and women in terms of who's entitled to take a period of leave after the birth of a child, and not distinguishing in the length of that leave on the basis of gender, is a strong constitutional argument. So I think employers would be good to start considering the implications of the judgment, to start considering how they would like their policies to look going forward. But there's nothing right now that they need to be concerned about until the Constitutional Court makes a decision.
And I think that's a very important point, because that's been our advice as well, is that don't miss this opportunity to start looking at policies. I think to the extent that your policies generally, as employers, differentiate between men and women regarding this type of leave, except for the duration, but whether one is paid, the other is unpaid, those types of things, those are problematic. They're very problematic provisions, according to this judgment, because this judgment indicates to us that when it comes to family leave, people should be treated the same, employees should be afforded the same, and this is where the thinking is going, and we definitely don't want to be caught off guard. I think what it would always also be doing for employers is employers need to be aware that your employees' thinking will start changing, because they are aware of this judgment. It's been widely publicized. Definitely in some of the circles I move in, people are talking about it, because I'm in a phase of my life where people are doing family planning. So they're considering this and considering what impact this may have on their families, and is this something that the father would like to do? This is definitely where thoughts are going. So to be proactive would be the right approach. I think one of the things I'd also like to mention, because I know there's been a bit of criticism on this judgment as to whether or not it's fair towards females or whether rights are being taken away. I think the principle to me was summarized so nicely in paragraph 27 of the judgment. If I can just take a moment to read it to the audience. It says that a major argument advanced to criticize this provision is that it is unfair on the mother to be deemed and doomed to be the principal caregiver, and the burden of childcare should be equally shared with the father. Parenting is sui generis and undoubtedly onerous, involving actual work, resilience in the face of exasperation, anxiety, unrelenting close attention to the newborn, extreme exhaustion, sacrifice of sleep, and sacrifice of the pursuit of other interests. And this is, to me, is what is important. A father who chooses to share in this experience for his own well-being, no less than that of his children and for their mother, can indeed complain that the absence of equal recognition in the BCA is unfair discrimination. A mother can, on the same premise, rightly complain that to assign her the role as the primary caregiver who should bear the rigors of parenthood single-handed is a choice that she and the father should make, not the legislature. And in denying the parents the right to choose for themselves impairs this dignity. And that really is the takeaway, because I'm seeing quite a few questions pop up about what happens to the remaining, or what happens to the other types of leave. I think what's important to understand is the intention was for there to now only be 4 months, and for you as a family to decide who takes the 4 months or who takes what portion of the 4 months, and that's why the word collectively was used. Now, it leaves a lot of questions, I have to be honest as well, because one of the things that come up in questions to us have been, well, administratively, how do you manage this between employers? How does one employer know one parent has taken a month and the other has taken 3. Administratively, this may be a nightmare. And I think what's important to note on that is those regulations and those guidelines aren't in place yet. So we have no clarity on how the Department of Employment and Labour will treat this. Is that right, Lisreen?
Yeah, and that's actually a very important point. So one of the issues that we raised in the judgment was the focus of this judgment is to look at, or the focus of the case that we brought to court was to look at the unconstitutionality of the statute. It was not to tell government how to then follow through with regulations. It's not to tell government how to allocate resources or how the UIF should be paying or what they should be paying. The point is simply this, that where there's a statute on the books that is unconstitutional, that it is the court's duty to declare it as such. After that, we leave policy decisions to government because that is their job, and there's a separation between the legislature and the judiciary. So the critical point is the minister came to court in response to our case and said the court should do nothing because this is a policy issue that should go to NEDLAC, for example. That was one of the arguments raised against us. The very simple answer to that is that it's absolutely right that it's a policy decision, but the question of whether or not it's constitutional or unconstitutional is not a policy decision. That's a legal decision. That's for the court to decide. After that, the court sends it off to Parliament and says, now, Parliament, knowing that the statute that you have on your books is unconstitutional, and knowing that these are all of the various deficiencies in the statute we point out, you, Parliament, need to go and consult. You need to go and talk to organised labour. You need to consult and decide how best to render the statute constitutional. So it's critical that people understand that it's not that the courts are trying to legislate. The courts are saying there's something wrong in this legislation. Parliament, you must fix it. And that's why the courts give Parliament a period of time to try and fix it. Where Parliament doesn't fix it in that period of time, then often what the Constitutional Court will do is to step in and say, if you haven't fixed it by 2 years from this judgment, for example, then we're providing an interim amendment to the statute to mean that the statute will now have to be read constitutionally and implemented constitutionally. But that only happens far down the line, far from where we are now. And in fact, even then, Parliament could still go and amend the legislation after that. So at the end of the day, Parliament is in charge of deciding how best to regulate this. And we know that even under the UIF Act, they're going to have to be regulations made. The UIF is already under siege. So they're going to have to start thinking about how does this work with the resources that we have. That's not for the courts to say, and that's certainly not any evidence that we led.
Very interesting, and there were various arguments before the court. I know the affordability was one of it by the Department of Employment and Labour, and some employers have raised the same, where that there's no judgment on that yet, and that would also still be considered as to those concerns for the Department of Employment and Labour to argue, so if I'm not mistaken.
Yeah, so I think, one of the problems that we had in this, and you'll see the judgment references this, is that both the minister and NIASA, the employers organization, did not put evidence before the court. They made very broad arguments about policy changes, but there was no evidence before the court, for example, of how many women apply for maternity benefits under to the UIF, or how many employees are covered by the UIF, for example, or what the financial implications would be if you allowed men to seek that benefit. So the court didn't have any of that information before it, and there was definitely, from the minister's perspective, the minister was lacking in terms of justifying the statute. One would have expected more evidence to be placed before the court, and it wasn't. All of that they have a second chance at doing before the Constitutional Court, and that is an obligation that our courts have repeatedly said that government needs to do. Come before the court, put the right evidence up so the court can make the best decision possible. But at the moment, just to reiterate, the court hasn't weighed in at all on any of those finer resource-based or fiscal-based requirements.
And Nazreen, when this goes to the Constitutional Court, is there scope for additional points to be considered? One of the things I'm thinking of when I see it's coming up in the questions, for example, is what is meant with collectively. In other words, can you as a parent or the both parents, can they still take a period together? In other words, those of us who are parents know it's quite a special time after the birth or after you have your baby and receive the baby, whether or not you take 10 days or 3 days, but that time at home is quite special. So it would be interesting to see, can this be interpreted to allow parents to still take it together, although it refers to collectively? My preliminary view on that would be as it's two employers, and we debated this yesterday in preparation for today, as it's two employers, there won't really be a reason to decline that request unless there are regulations by the Department of Employment and Labour stipulating otherwise. But it shouldn't impact an employer to allow people to take it together. But there are other things like the parental leave, 10 days have fallen away completely. We all know that 3 days in terms of family responsibility leave fell away in June, which means we are now left with this 4 months. And we need to think about practically, is there any more guidance required as to how this can be taken, when this can be taken, what employees should do in providing proof of who takes when? All of these questions remain to be answered.
Yeah, look, I think that there are some difficulties with the order that's made. I think what we see in the order is an attempt to find some, not a middle ground, but to link the relief sought by us, the first and second applicants, that's the Van Wyks, and then the Centre for, or the Commission for Gender Equality. And so you see that in trying to, I think the language could be clearer so that it's absolutely clear who gets to take what when, but I don't think it matters as much because it'll be fixed in the Constitutional Court. So for example, at the moment, the way it reads, if you look at the order, the way it reads is that either parent has to take the whole of the period, or you have to take turns at taking the leave. Now, if you just on a kind of straight interpretation of that language, it doesn't suggest that you can overlap that leave. It suggests that that one parent, for example, will take 2 months, and then the last 2 months the second parent takes. But that's certainly wasn't the relief that we sought. But I think that's an attempt to equalize the playing field by the judge. I think it's something that we will raise in the Constitutional Court to try and be absolutely clear what is meant or what is appropriate in order to achieve to fix the inequality. There also, there's no way of knowing unless there are regulations put in force that synchronizes all of the information between different employers. So if you and I were partners and we had a child together and we were employed by different people, there's no way that each of our employers is going to know which of us is taking leave and when. So the way it's drafted at the moment, there's scope for people to take leave at the same time, but I would imagine that's something that Parliament will consider and regulate appropriately. There are lots of countries where both parents are entitled to take leave at the same time, and we canvassed that to some extent during argument. It wasn't our argument, but Sonke Gender Justice placed that evidence before the court. And there are various international instruments as well that recognize this need. And the basic idea is that in an ideal family situation, you would like both parents to be at home together for the first period of a child's life. Now, we know that the realities of life preclude that. And we also know that socially, one would imagine that not much is going to change, that mostly women are going to continue to be the primary caregivers and benefit from this leave. So I don't think it's necessarily a provision that the judgment discriminates against women. And we also know that very few fathers are going to make use of this provision. So it's although this is a groundbreaking judgment, I am skeptical about how much that will change because of social constructs and the ideas of who in a family is the primary caregiver. And perhaps that will change with time, but it's certainly not going to change overnight.
Yeah. It would be interesting to see how many fathers would prefer to stay home or how many supporting partners would like to take on that role. The one thing that's also come up is the 6-week period, where the 6 weeks is usually prescribed for recovery. of a birthing mother. So I assume that's also something that will be clarified in the Constitutional Court. But I think what to add to that is that employers need to remember, depending on the manner in which the specific birthing mother may have given birth, it may be a set period prescribed by her doctors that she would need to take as part of that leave. And then we would assume that would still form part of the 4 months and not be over and above. So those are all still questions we all have, and we're excited to see the responses to that. I just want to see some of the questions.
While you're looking for that, Anli, let me just say on that we were quite clear in our argument that, and the judgment does talk about this, that the Act specifically provides for the physiological requirements of a woman after giving birth. So that idea that you may not work for the 6 weeks after giving birth is to provide some level of protection for a birthing mother. And our argument was certainly that shouldn't be touched. For very obvious reasons. The real issue is who then becomes the primary caregiver after you take care of the mother's health, which we say the statute does do. Who then is the one that stays home with the child if they want to? And the other thing to kind of realize is that there aren't, there's a proportion of people that will claim benefits from UIF, but it's not it's up to, 75% of your salary as a max, I think. If that's so, one does have to question how many people are going to actively take this leave if they're not guaranteed that full salary. And so that's another limitation on the sort of floodgates concern that employers may have.
I agree with you on that. I don't think the concern is going to be that it's going to throw everything out the window that we knew previously. Where it's going to have its impact is on existing policy provisions, where there may be an argument that you're treating people differently, which shouldn't be the case. So I think it provides a basis for employers to go and look at policies, but I don't think we're going to see a mass exodus of supporting partners to take what would I assume be parental leave now, and the traditionally primary caregiver returning to home or returning to work. I think was one of the interesting principles of the judgment as well is that it said the focus of this judgment isn't limited to, for example, the physiological needs such as breastfeeding. This is a nurturing question. I think that's also important for the audience to understand. It's about the fact that both partners in a relationship can take on the role of the nurturing of a baby. And that should be for the family to decide as to who does that. It doesn't take away any rights from a mother to care for her child. It just gives you more power as a couple or as a partnership to decide who gets to stay. I want to go to some of the questions. Right. We may have addressed some of them already. How do the parents that work for different employers, how is that managed? We said we don't know how that would be. We assume there will be Department of Employment and Labour may issue some guidelines if we get to that point. Is there still the mandatory period for a birthing mother before and after giving birth? Nasrina's confirmed that's very much formed part of their argument that that's an essential. And I would assume that that's supported by 6 certificates in any event, and nothing about that would change. Then a question on current situation of 4 months maternity leave and 10 days for the father, but now it's only 4 months, so shortchanged by 10 days.
Yeah.
Yes.
I think that is a flaw in the judgment. That notionally you are shortchanged by the 10 days that a father would have received, and I think that's something that must be considered by the Constitutional Court. There's a theory in constitutional jurisprudence called graveyard equality, and the idea is that in finding equality, you either raise everyone up or you raise everyone down, and one tries to, or you lower everyone down, I should say, and one tries to find somewhere in between, and ideally you want to sort of lift everyone up to the correct standard of equality. But the loss of the 10 days is a good example of us losing something in this judgment, and it would take some quite careful crafting to try and amend the legislation in such a way that you allow for 10 days parental leave. Perhaps you would say 10 days parental leave or a period of 4 months if you're the primary caregiver. One of the suggestions we made was for people to identify who was the primary caregiver and who's the secondary caregiver, and that then you could identify who got what leave. But I think what the judgment shows is that it is an incredibly difficult thing to try and regulate. And that's why Parliament needs to do the work, and the process of consultation has to be very active and engaging, because there are lots of little things that one or court may not think about that needs to be brought to its attention. So this process of going to the Constitutional Court, I think, is very important.
The one you said that just now, that not everything could have been regulated. I mean, there are so many scenarios of what can still come and what needs to be provided for. One of which, and this is one that I gave some thought to as well, is if one parent is unemployed, can the employed parent take 4 months? It's possible. It is possible. So it means if you have a relationship where one parent is a stay-at-home parent in any event, the supporting parent can now take 4 months.
Yes.
Not both would be able to claim. I think that would need to be taken into account. So there's a financial burden. But that means, and this goes to this graveyard principle that you spoke to about just now, where that scenario, all of a sudden you could have both parents at home for 4 months, where in other cases you need to split the 4.
Absolutely.
So it's interesting when you start thinking about the different scenarios and how it would play out in different families. It's just very interesting. Then a question on current situation of 4 months maternity leave and 10 days for the father, but now it is only 4 months. Okay, so short change by 10. We've done that question. Can Mr. Van Wyk retrospectively apply for his UIF benefit?
I'm not sure. I wouldn't imagine that would be easy for him to get. I don't think so.
And I think you have a set period of time in which to apply for that.
Yeah.
No,
that's certainly not my area of expertise, so I won't give you advice on that. But my gut is to say probably not.
Yeah, same here. But Mr. Van Wyk must be feeling very validated in his argument and his request.
Part of the thing we had to think about was whether or not one of the arguments that we faced was, this may be moot. They've had their child now, but in truth, they may have other children, and there is a broader impact on other families. So it does remain relevant. One of the questions I saw come through was around what happens with the Constitutional Court and the period of time that Parliament is given to fix the problem, and when it runs from. I think that was the question. The short answer is that if Parliament is given 2 years to amend the legislation, it will only be from the time the Constitutional Court decision comes down. So it's not 2 years from now. It's 2 years from when the Constitutional Court decides to give Parliament 2 years. And as I say, the court may say this isn't discrimination at all and find that the statute's constitutional. So that still is open to them as well.
I think we've addressed most of the question. There's a last one. Is family responsibility leave still applicable? No, because family responsibility leave was changed 2 years ago to take out the birth of a baby. Whether or not that comes back in, we'll have to see, or the birth of the child. I think the other point, one of the last points I just want to mention, is one of the arguments before the court was to extend the date for adoption leave, or to extend the age beyond the age of 2. So in other words, if you adopt children older than 2, you should get similar benefits. That was not granted. So that remains, that status quo remains. Adoption leave is for people who adopt a child below the age of 2.
Yeah.
Nazreen, to me, this is a very interesting topic. Maybe we'll speak again once you're in the Constitutional Court. Are there any closing remarks from your side on this judgment?
I think just to say to employers, because my sense from not just these questions that have come up today, but also just hearing what's being said in the media and elsewhere, is that this is just to reiterate, we've said it several times today, but nothing changes tomorrow. And what it is an indication of where we are going, I think. And so it's good for employers to get ahead of this, to start thinking about what they would like their practices, policies to look like, how they would manage that within their organizations, and whether or not they want to participate through whatever forum in the consultation processes that will happen in due course on the amendment of the statute. But I think, thank you very much for having me on, and thank you to everyone for listening.
Thank you so much for making the time. To recap, everyone, the judgment says 4 months collectively between the two. All other types of leave, we'll have to see what happens. But this is very interesting. We'll definitely keep an eye out, and we will be keeping everyone updated in terms of our alerts as well. Thank you, Nasreen. I really appreciate your time. I know you have to be in court in 25 minutes, so we
Yes,
appreciate
thank you.
it.
Thanks very much.
Thank you.
Take care. Bye.
Visions are desires that flicker between a wish and intent. They are carvings waiting for the artisan's hand. One who is consumed by purpose. One who can bring vision to fruition. Cliff Decker Hofmeyer, incorporating Kieti law from vision to fruition.